Distinguished speaker of the day, Honorable Mr. V. Jagannathan, I, on my own behalf, on behalf of the Gokhale Institute of Public Affairs and Indian Liberal Group Bengaluru chapter, of which I happen to be the president, extend a hearty welcome to you. Mr. Jagannathan will be speaking on a very topical, interesting, and it's a very vast subject. Changing laws in the country. Of course, for every one of us, it is topical. It is everyday topical. Only one word I will say. Oliver Wendell Holmes, one of the greatest judges of this world. He is considered to be one of the greatest judges of the world. He was elevated to the Supreme Court of America at the age of 60. He retired at the age of 92 and died at the age of 94. He has written a book called Common Law. In that book, one of the sentences is, "Law is not logic, but life." Once again I will, law is not logic, but life. Life, particularly society will be ever changing. It will not be static. Therefore, changes in the society is a very topical subject. Every one of us look forward to benefit from the speech of Mr. Jagannathan. I will now introduce Mr. Justice Jagannathan was born on 9/9/50 at Bengaluru, obtained BSc degree from Mysore University, then he obtained LLB degree from Bengaluru University. Pursued higher studies in law by joining for LLM course in University Law College, Bengaluru. Completed LLM degree with specialization in labor laws and was awarded gold medal in LLM. Enrolled as an advocate in the year 1982 in Bengaluru, joined the well-known firm of advocates and solicitors of King and Partridge, Bengaluru, and worked under the eminent advocate Sri K. Kasturi. He used to appear before me when he was working with the King and Partridge, particularly in taxation matters, I believe.
Yes, right.
Set up independent practice in the year 1986 and continued till 1993. Practiced in the High Court, Labour Courts and Service Tribunals. Also taught law in prestigious law colleges of Bengaluru for over 7 years as a professor of law, and the subjects taught included jurisprudence, Mohammedan law, and labor law. Joined directly as district and sessions judge in the year 1983 and worked in that capacity in several districts of Karnataka. Held the position of Registrar Judicial in the High Court of Karnataka for a brief period before being posted to Karnataka Judicial Academy as senior faculty member. Friends, if any of you have interest in law, I request you to visit that Judicial Academy. You may kindly go through that library. You will find it is one of the best law libraries as I have seen in Bengaluru. And that very much owes to Mr. Jagannathan, Justice Jagannathan. Of course, I had also gone and done some research work there. He tells me today, yes, I was there when you came there, and held the position of judicial, became the director of Karnataka Judicial Academy in the year 2000 and held that position for 5 years, and during this period presented several papers and articles numbering nearly 100 in various seminars and workshops, apart from organizing several regional, national and international seminars, workshops on subjects like environmental law, gender justice, criminal justice system, child labor, elevated as a judge of the High Court of Karnataka on 7/3/2005. He recently retired as a judge of the Karnataka High Court about a month ago. Of course, I do not want to say what will be the further avenues open to him. That is a matter on which I don't want to say anything. But with these few words, sir, I request Honorable Mr. Justice Jagannathan to deliver his interesting lecture. Thank you very much, sir.
President of Indian Liberal Group, Honorable Justice K.S. Putswamy, Secretary of the Gokhale Institute of Public Affairs, V.R. Ramaswamy, distinguished audience, ladies and gentlemen. In his welcome address, Justice Putswamy has shown his great affection for me and has spoken very high of me, and I don't know how much of it I really deserve. It's only due to his goodness and large-heartedness. He thought of mentioning those things, and in the course of his welcome address also he mentioned that the topic that is selected today for discussion is a very topical one and very interesting one and very important one. And very rightly he has set the tone for the address by mentioning these things. And as far as the Judicial Academy Library is concerned, though he said it because of me, that library has become one of the best libraries in the country. I would like to say that it was also due to efforts of the President and Governors of the Academy then, and many other distinguished persons who joined hands in building up a very beautiful library. And my contribution is only a very, very small one. And therefore, I am thankful to Justice Putswamy for his very kind words. And Gokhale Institute is not new to me, and I would like to mention at this juncture that my classmate in LLM, Mr. H.S. Chandrasekhar, who is an advocate and present in this hall, has been mainly instrumental in bringing me to this wonderful institute. It has got a very high reputation over several decades, and many eminent personalities have shared the dais and have spoken on very many subjects. And as far as D.B. Gundappa is concerned, let me tell you, I have got a great liking for DBG for two reasons. One is, I read this Mankutima Kagga when I was very young, studying in my college. And second is, later on, the first book that I read of DBG was a very small book, about 10 to 15 pages, called Bali Vandu Nambike. That book inspired me to read more of his books. And then, since I have a very philosophical and spiritual bent of mind from very young age, I happened to lay my hands on another great work of DBG, that is known as Jivana Dharma Yoga, or commentary on Bhagavad Gita. That also inspired me, and then I went on to read other books of DBG also, like Bhavan Navasagi and many other books. And I have a very great liking for the very great eminent author whose name is a household name in the literary field and also in entire Karnataka, apart from being a very distinguished personality by himself. And it is these two factors that has prompted me to come to this institute once again and to share a few thoughts of mine on the topic. Justice Putswamy in his address also mentioned that this topic is a very vast one, and I may not be able to take you through the entire subject within the time allotted to me by the Secretary and other officers, but it shall be my endeavour to say a few things so that it will prompt you to a better awareness of what's happening in the society, whether the law should change or whether it should remain the same, what are the implications if the law doesn't change, what will happen to society. These are some of the, I think, thoughts which I hope to awaken in your minds, and I hope my endeavor would be successful in this arduous task which I have taken upon myself. The topic for discussion is the one which is very, very relevant in today's society. Should law remain the same for all time to come? Should the contents of law remain the same for all time to come? If the reasons which prompts a law to be brought into place ceases to be valid, should we still continue to have the very same law, notwithstanding the changes taking place in the society? Should not law be modified? What will happen if law lags behind and society goes on progressing by leaps and bounds? What will be the implications? It is on these aspects I come here to share my thoughts with all of you, distinguished gathering and enlightened audience present here. The topic is law in a changing society. As the very topic itself indicates, society keeps on changing. It has to change, it will change. But what is the position of law? Should the law remain same? Or law also will have to march shoulder to shoulder with the society changes? Is the question that we seek an answer in this address. Before I go to the topic as such, let me also tell you very briefly what we mean by law. Because when we speak of law, one also would like to know what the concept law stands for. There have been many theories about the concept of law. Great writers and jurists have spoken about what law is. There have been several theories of law over several decades, and the entire subject of jurisprudence deals with the concept of law, the function of law, and the purpose of law. Several theories have been there and continue to come up. But for a common man, a law means what? Law is nothing but rules of conduct for human behavior. Our human behavior in society is thought to be regulated by rules, by principles. These rules and principles, which are recognized by the courts, are called in simple terms as law. In other words, Supreme Court in one of the cases, Dalmia Cements Company case, went on to say that in a very simple words, law is nothing but the manifestation of the principles of justice, equity, and good conscience. According to one great British jurist, John Austin, law is nothing but a series of commands which will have to be obeyed by the citizen, whether I like it or not. Once the law is passed, I am bound to obey the law. There is no second thought about it. And according to Austin theory of law and morals are separate, and one has got nothing to do with the other. I will not like a particular rule of law because it is opposed to morality, but nevertheless, it is a series of commands issued by the sovereign state. We are bound to obey the law. This is what the theory of Austin is. Other great jurist of America, by name Roscoe Pound, came up with another theory of law. According to him, the law is nothing but it is an instrument of social engineering. What do you mean by social engineering? Trying to balance various interests in society. Individual interest, social interest, public interest are sought to be balanced by the instrument of law. This is what Roscoe Pound has said. Therefore, for our purpose, we will take it that law is nothing but rules of human conduct to regulate the behavior of the people in society. Therefore, law does not operate in a vacuum. It requires society, requires people. In jungle, there is no law because people don't live there. Maybe nowadays people may go to jungle also, but all said and done, law does not operate in a vacuum. In society, law has got its same role to play. Now, if this is the definition of law. We will ask a question as to why should the law undergo a change? Why can't the contents of law remain the same for all time to come and all circumstances? In this connection, it will be very useful at the outset to recall what a great British judge and master of rules, Lord Denning, has said in his book called The Family Story. This is what Denning says, I quote, "The rule of law, when enunciated by legislators or judge, are usually founded on reason, which appears to be satisfactory at the time of making the law. Once these rules are given the force of law, they must be obeyed for their own sake and not for the goodness of the reasons behind those rules. No society can permit its members to disobey its laws simply because they disapprove the reason behind that particular law. In course of time, the reason itself may cease to be valid. Then what should happen to the law? The law remains, the rule remains binding. Or if this were to happen, what will be the consequences? New days, new thinking of the people, new outlook, new changes taking place in society, all make the society to progress far ahead of the law. A gap is created between the law and society. This gap continues to exist and it is a perpetual one. Therefore, the law will have to march along the society's ideas, thinking, mores, etc. The world rules must be modified, or else what will happen? Society itself will stagnate. Because law is very old. Society has gone far ahead. We don't change the law, we don't modify the law, society will stagnate. This is not the purpose of law. Law has to keep in tune with the development taking place and the changing thoughts in society. A great author and a very well-known personality, Henry Wayne, the author of Hindu Law also, has said the following about the need for change in the law. Why should law change? He says, social necessities and social opinion are always more or less in advance of law. We may come indefinitely near to closing of the gap between them, but it has a perpetual tendency to reopen. Law is stable. The societies which are finishing up are always progressive. The greater or less happiness of a people depend on the degree of promptitude or with which this gulf is narrowed. Therefore, the law will have to get itself modified, it has to change, so that it will also go along with the society's changes. Then the gap will be narrowed. But the gap can never be filled up. Every day changes take place in society. We might have seen in the papers a few days back that in a case where a person donates his sperm for the birth of a child, whether he should take the consent of his wife or not. Now, because I'll be talking about that topic also in course of my talk, in my when I come to the family law topic there. But just to mention here at this juncture, now a debate has arisen in Western country that whenever a person donates his sperm to help somebody else to have a child, whether the consent of the wife is required or not. Now a lady has gone to the court saying since I am married to this person, we have a marital relationship. Therefore, he cannot donate his sperm without my consent. It is now a matrimonial property. That is the argument of that lady, and our matter has gone to the English courts, and we have to see what is going to happen. Why I mentioned this is so much of change taking place in society. Law also will have to change. Unless it happens, we will be lagging far, far behind. Having said this, what are the modes by which the law is modified? Is the next question that may crop up in our minds. So, law is modified through several agencies or through several modes. One is through law making itself. The Parliament itself will make a law replacing the old law, make amendments, bring in new provisions of law. Through legislation, law gets modified. Second is the advancement in science and technology, medical science, genetic engineering, computer technology. They all have played a very, very great role in changing the very shape of law itself. The third, of course, is judicial decisions of the courts have also played a great role in changing the law. Now, these are the three main modes of law getting modified in society. Now, this modification of law will also depend on yet another factor, namely the interplay between state action and social opinion. They will also have a role to play, and the kind of interaction between the state and social opinion will also depend upon the type of government that you have in society at a particular period. If you take the dictatorship form of government, there the government controls every organ of the state. Whatever law is made, we are bound to obey it. The state can even mold the minds of the people by bringing in whatever law it wants. We have no choice. That is in a system of dictatorship. But what about a democratic type of government, which we have in our country and also in some of the other Western countries? In a democratic type of government, there is more scope for interaction between the state and the social opinion. It is a more articulate one and a more obvious one. Because in a democratic setup of government, people have a great say in every matter. Legislators or representatives will bring in before the Parliament very many issues, and they seek changes in the law. Not only legislators, publics, the people who are called as the common man, the press, radio, electronic media, all play a very, very vital role in shaping the public opinion, and the government of the day will sometimes yield to the pressure of the public and bring about necessary change in the law. You all know now what's happening in the country now. Now there is a huge debate going on about the menace of corruption, how to bring it down. We have seen how many hurdles have been there in the passing of the Lokpal bill now, because this great public opinion is being generated everywhere in the country. People are fed up with corruption. Now they want to change in the law. So in a democratic set of government, there is a lot of scope for interaction between the state on the one side and public opinion through social media, social opinion, etc. on the other hand. This is also one of the aspects to be kept in mind. Now sometimes the government of the day will be very lethargic, may not show any interest in some issues. Public opinion also may be indifferent, neither is not that is their views. In such situation, some individual comes up, some minor groups, some social groups, they come up, they take up a particular issue and fight out, and finally law gets changed. The entire law of environment is nothing but an account of few individuals. They took it before the court through various boards like PAL, etc. And today we got a mass of case laws on environmental law. Therefore, this also a factor which contributes for the change in the law. In America, a member of parliament by name Mr. A.P. Herbert single-handedly brought about liberalization of the divorce law by his own individual efforts. Therefore, individuals, students of universities, they can also take up these issues and seek a change in the law due to various factors. Now, this legal change also occurs in a society where there is a revolution. A revolution takes place, just as we had the French Revolution in 1789. The French Revolution led to overthrowing the existing legal order, and a new one was put in place in French because of French Revolution. Due to the world wars, Germany and Japan also had to change their constitutions because the pressure came from the victorious people who had won the war and the enemies. Because of the outside pressure, changes in constitutional law were made in Germany and also in Japan. Therefore, revolutions also play a role in changing the content of law. There's one more thing, civil disobedience. Civil disobedience also gives rise to changes in the law. The best example that can be given is that of America. And we all know and we have heard about Dr. Martin Luther King, who fought single-handedly on behalf of the black people, called the Negroes. There was discrimination between the blacks and the whites in America, and his efforts ultimately led to passing of an act in America. And today we don't have that kind of discrimination, and even a black person became president of America, so history tells us. So these are all the factors which play a role in changing the content of law. Now, with these preliminary observations, I would like to take you through some of the concepts of law and place it before you for your consideration and for your thinking as to how the law has changed over the years and in these areas of law. The first one which I would like to take upon is the concept of property. Let us take the concept of property. In the earliest time, the concept of property was taken as or understood as nothing but anything that is capable of being owned. Anything that is capable of being owned is called the concept of property. Whatever I can own is my property. It therefore included material things, lands, etc. But this concept of a property that is capable of owning anything by a person has now given way for a wider interpretation or wider understanding of the concept of property. With the development taking place in society, today we have Patent Acts, Copyrights Act, Trademarks Act. All these are generally called under the term intellectual property. Today, apart from the right we have over the property which is tangible, which is movable or immovable, a person can also have right to property with regard to his intellectual property rights. What do you mean by intellectual property rights? It is nothing but something that is created out of one's own intellectual power. I write a book, I write a novel, I write a drama. It is my creation. I have created the novel. I have the right over that work. Likewise, there are many things over which a person can have a right so long as he is able to show that that is nothing but the creation of his own intellectual efforts. Now today, this concept of property therefore has been widened. It encompasses many other rights also. Not only that, a thing over which I have a right, I say it is my property. But now the procedure has changed so much that several persons can also have a right over the same thing. If I have a pen, if I say it is my pen, I am the owner of it. But let us take an example of a land. I am the owner of a land. I am the owner of the land. Or let us say A, the owner of the land. A gives that property in a mortgage to B. So B as a mortgagee has got some rights over the very same property. Then we'll go a little further. B, who is the mortgagee, gives it to C. C becomes the tenant of that particular land. C enjoys certain rights over the land, gets the products from the land, he enjoys it. So now we have same property there, but they are different persons having different rights over the property. So it's nothing but now the concept of property has been understood as having a right over a particular thing. It is not necessary that only one man must have a right. Several persons can have a right over the property. Now look at the industrial law now. With the development of labor movement, the property of the company, workers have got a say. They say, you don't sell it until you decide our matters. You have no right. So the concept is now changing. It's encompassing very many areas and therefore the change that's occurring in the concept of property is because of this development taking place in the society. Then, what about the right of a person who has got some information put up in the internet? He says, it is my property. I am not having it in my hand, but the property is mine. The design, the web address, the domain, etc. belongs to me. That's also now a kind of right which a person has got. So the concept is changing so fast because of the development taking place in society. And today we have what is called a cyber world in contrast to a real world. Real world is what we are living in a real world. But cyber world is nothing but a virtual world. What happens in the virtual or cyber world has got its impact in the real world. So much is taking place in society. Should not law address all these issues? Should not law undergo the changes to meet these complex things happening in society? Now, the concept of property has also now led to the employers, the factory owners, and even land owners' rights being affected. Today, I am an employer, I have a factory, I own machineries, but the law says you properly fence your machinery, let not the workers get affected by it. Put them in safe place, keep them in safe conditions. These are all the provisions of law which we have under various labor enactments. Therefore, the concept of property is undergoing a change. The needs of the country, defense needs, economic emergencies, conservation and utilizing the existing land and mineral resources have all led to the change in the concept of property. Town planning acts are there, housing control acts are there. Today, the owner of a house is bound to maintain the house in good condition. The tenant will not pay rent, will go to court, not in good condition, ask him to do it. So this is how the concept of property is getting expanded, and it is not confined to the earlier view of one man having a property, having all rights in the property all to by himself. That situation no longer exist. New social and economic philosophies have influenced the concept of a property. Let me go to the branch of crime and criminal law. What's happening now in the criminal law now? Let us see now. What is the purpose of criminal law? The purpose of criminal law, according to a great author, is to express a formal social condemnation of a forbidden act. An act is forbidden, and criminal law condemns him by saying, if you do that, you will be punished. Buttressed by the sanction of punishment to prevent it. Now, the criminal law, as in its earlier stages, has been confined to only private persons, individuals. You take our Indian Penal Code, there are various offences have been defined, but are those offences are the only offences we have today? Are there not many other offences? Now, the approach of criminal law itself is now changing, and there are very complex situations that have arisen on account of change taking place in society. Today, it is not an act of committing theft or committing murder, etc., is taken or treated as an offence. Even not obtaining a license, not following certain regulations, not maintaining the proper books of wages, etc., various laws, they prescribe punishment for various offences. We got the Narcotic Drugs Act, carrying drugs from cannibal, etc., is an offence. So many economic offences have now come into being, thereby changing the landscape of the criminal law itself. Now, let us take the economic crimes now. An act of a person which was once a legitimate act is now looked upon as a crime on account of public controlled economy. At the same time, we have situation now that in the area of sexual behavior, the changing attitude, changing social morality, changing social conditions have led to abolition of criminality of such behavior. Today, we all know, and we have been reading in the papers and also hearing from many sources, that persons belonging to the same sex or homosexuals, two males in private, if they live together, it is not seen as an offence at all in many of the Western countries. And there are cases pending in the Supreme Court also on this aspect today. So, what was once a legitimate act is now being looked upon as a criminal act, as an offence. And conversely, what was a taboo in society is now being given a liberal understanding, and the criminality of such behavior has been now given a go by. These changes are taking place in the field of economic crimes here. Now, as far as public control economy area is concerned, today the rape of the earth, deforestation, wasting of water, wasting of useful resources have been looked upon as a crime and as an offence. The entire law of environment is nothing but the violations and the breach of several provisions of law gives rise to economic offences. Polluter pays the principle, as was declared by Supreme Court in Union Carbide's case. Now, if a factory has got the waste material and that water is allowed to go into the river, etc., he will be hauled up for contaminating the river water. No, it was not an offence in earlier days. Look at IPC now. This is one thing now. The second one is that about this sexual behavior. Now, Parnitva behavior which were not accepted in society earlier are slowly being given a stamp of approval by various countries. And one such example is this sexual behavior and homosexual conduct between consenting adult males carried out in private. And another one is abolition of criminality of abortion. Abortion is today changing the face of the law itself, in the sense in several countries they are given permission, abortion has been legalized. In some countries certain periods are given, saying within this period the woman is given right to have abortion. If this is beyond this particular period, state will intervene. If it is beyond yet another period, state will not permit abortion at all. This is happening in many countries now. In America, in a very well-known case known as Roe versus Wade, it was held by the Supreme Court there that in respect of this abortion, they took up 3 periods, trimesters. It said that in the first trimester, between 1 to 12 weeks, it is the right of the woman to have the abortion. In the second trimester, that is from 12 to 20 weeks, the state will also come in the picture and will ask you why you are going for this, what are the reasons, satisfy us as to why you want to get rid of the child. Second stage. The third stage is between about 20 weeks. When at about 20 weeks, if the woman wants to get abortion, the law says we will not be allowed to go on with abortion. This is how the changes are taking place in several countries, and as far as India is concerned, we have passed what is called as a Medical Termination of Pregnancy Act in 1971 to prevent illegal abortions. Despite the act being in place, illegal abortions are going on scot-free in the country, because the act has got many loopholes and they find it very difficult to comply with the provisions of law. Therefore, this is one field which is also changing the very concept of law itself now. There is a debate going on in several countries, right to abort versus right to birth. A debate is going on, and there is an interesting article on this topic, Women's Right to Abort, which is published in Supreme Court Journal, 2011, volume 10, SEC Journal section J23. 2 students of a National Law School of University of Raipur, they have written an article about this entire concept of abortion, how the laws are getting changed in several countries, what should be done in India also. They say ultimately in their article that you should try to reach a balanced approach which will benefit both the mother as well as the society and child, etc. Therefore, this one area which is now undergoing series of change. You might have seen in the papers, I think only about 2 days back, that there is a thinking going on to legalize or to even suicides. You might have read it in the paper in very few days. There was an article, I think, in Karnataka, something like that. Suicide also should be held to be not a crime. Now, what's going to happen? We will have to wait and see. Now, there are so many views being expressed by people now. If you say it is not a crime, poor all, people may will resort to suicide. And if you don't permit them, what will happen? So, these are all issues which are very relevant today, as rightly mentioned by Justice K. Puswami, topical issues. It concerns everybody, and the awareness in the people, and also the thinking of society ultimately will decide as to what is going to happen in these areas. The next area in the criminal law is cyber crimes. Now, today we have what are called cyber crimes. Internet came to India in the year 1995. Now we are in 2012. Look at the havoc it has created. Today, a lady in Delhi, working in an embassy in Delhi. She was harassed by a person. He took out her photograph. She had put up her address, everything on the website. While she was surfing the internet, this man picked up everything from her, sent her the nude photographs, told her, if you don't pay me this much of money, I will expose you. We are seeing this nowadays in paper also these things. These are all very serious crimes that's taking place in the cyber world. Law should be very effective to control the cyber crimes. And let me also tell you about a very, very interesting case which is known as a love bug virus. This love bug virus, it happened in Hong Kong in 2000, 11th of May in 2000. This virus spread all over the world. The impact was this. It destroyed the 2000 digital photographs in Germany. This virus went on to destroy the ATMs in Belgium. People were having no cash at all. ATMs were destroyed. This virus led to closing off a very, very famous cosmetic company called L'Oréal in France. Business was shut down. British Parliament shut down its website. America had also had a lot of problems. NASA and CIA were also not spared by this love bug virus. In just 2 hours, this love bug virus traveled throughout the world and it affected 45 million users in 20 countries. This is the impact of the cyber crime that took place in year 2000. Now, who was the culprit? Who was the man who was responsible for this destroying of all these things? He was a person by name O'Neill D. Guzman. He was the person who did this business of it, putting virus into the internet now. Was he convicted? Was he put on trial? He belonged to Philippines. From Philippines, this virus was generated. He could not be put on trial. Why? There was no law at all. There was no law in Philippines to tackle this kind of crime. He escaped unscathed. This is the impact of this computer and internet. Now we have the real world opposed to the virtual world. I said the virtual world is nothing but the world of cyberspace. Now the internet has now changed the whole concept of jurisdiction now. If you look at the CPC or any civil law, we find that court will have a jurisdiction in respect of a property which is within its jurisdiction, not a property having property in some other jurisdiction. This is a very simple concept of jurisdiction. But today, where is the jurisdiction for cyber crimes, cyberspace, to whom it belongs? It encompasses the whole world. Where got jurisdiction was cyberspace. Now, law is required to tackle this menace. Other day I saw in the paper about efforts being made in Japan to somehow tackle this problem of cyber crimes happening in this cyberspace. Let me give you a small example now. A trademark is registered in India. This trademark may not be registered in China. India has been registered as a trademark. Now, if you look at the internet and if you find that China has got a trademark which is similar to the trademark which I have, what will happen? Will there not be a conflict between the two who are engaged in the same business about the same similarity of the trademark? Which court will have jurisdiction? How will you solve this problem? So these are all very many issues which has now made the legislature to awake from their slumber and tackle this problem, and law also has to keep in change. These cyber crimes, they take place through various modes. They are called cyber pornography, cyber harassment, hacking, cracking, cyber crimes against the government. Let me tell you an interesting case. In America, a patient was in the hospital. He was given a particular drug by the doctor concerned. They write on the prescription, the nurse will give the drug at a periodical time to the patient. A person who wanted to get rid of this patient and staying elsewhere, away from America, he hacked the internet. He substituted a drug not prescribed by the doctor himself. That drug was given by nurse to the patient, and the patient died. Now, this is happening in the cyber world, in internet. How to tackle this? Should not allow now also march ahead and find solutions. Otherwise, today the privacy of individual is totally invaded. Everybody will know about everybody else, everything. There is nothing now to call as secrecy at all. But right to secrecy is also a right recognized by Declaration of Human Rights. But today what's happening? People are getting exposed. Everything is on the net now. Therefore, the criminal law and the criminal sanction also need to undergo lots of changes because of this development taking place in the society, particularly in the field of computation and technology and internet now. Now let me move on to another concept, a very interesting one, which has engaged the minds of lots of people in the country, women groups, and even the courts. That is the area of family law. Let us go to the family law. The family law has also undergone lot of changes on account of various factors. These factors are the freedom of the individual, transformation in economic status of the family in modern society, scientific and medical developments, and the change taking place in the social morality of the people itself. These have contributed to the far-reaching changes in the family law. Let us take, for example, the concept of, we have a concept of family. We take a marriage. What do you mean by marriage? Between two persons, they marry according to the provisions of the law and whatever the rules which they have to follow to make it valid. Marriage take place, there is a valid marriage. We got Hindu law, we got something like Saptabadi, etc., etc. So we have got a marriage means husband and wife are there. Supposing the husband, while having the wife, while having the legally wedded wife with him, while she is alive, he happens to spend his time with another lady. The married person and the lady, they live together for some time, almost like husband and wife. What do you call that kind of relationship? Do you call it as marriage? Do you call it as something else? Now a new concept has come into being. It is called live-in relationship. Live-in. Now look at the changes now taking place in this area of law. Far-reaching changes are taking place now. It is an arrangement or an agreement where heterosexual couple live together. They live together without entering into a formal marriage. They don't enter into formal marriage at all, but they live together for many years of certain period of time. What will happen to the rights of the children born to them? What will happen to the property rights of these two partners? Who will get the property? Suppose in the man days, what will happen to that lady? In Hindu law, Hindu Succession Act says, if the husband dies, the widow is taken as one of the class 1 heirs. She is a class 1 heir in Succession Act. What about living relationship? Where do they stand? Is there anything like a property being given to her, that lady? What will happen if property is given to her? Will it not cause harm to the legally wedded wife and her children? These are all very complex issues now threatening society, and law has to find some solution to these problems. Now, this living relationship also has arisen on account of two factors. One is by choice, second is by circumstance. What do you mean by choice? Now, in many places, in big cities like Mumbai, Delhi, and other big cities, even in Bangalore also now, young couple not being married live together. You know, in the olden days, the landlord never used to give the house to a single person. They will say, "Are you a single person? I will not give you my house." Even many movies have been, we have come, we have seen all those. They take a lady and she told us, "My wife," they go and stay there in that house. This is one of the factors in the earlier days. Now, because of the economical status, people go and work in different places. Husband is in one place, wife is in some other place. Or young couples who do not want to go through the entire ordeal of marriage, they say, "Let us live freely. Let us not marry, but let us live together." This is happening. This is by choice. By choice, they decide to stay under the same roof for a period of time. This is one kind of living relationship. The second one is by circumstance. A marriage takes place, but it is not known to the parties that the consent was obtained by fraud. When consent is obtained by fraud, that is not a valid marriage. Then what will happen to the status of the parties? Or a woman, not knowing that the person is already a married man, joins him. He tells her, "I am not married." They live together. She gives birth to a child. Then she later on comes to know this man has got already a wife living and children are there. What should happen to that lady and to the child born to her? Now, these are all serious issues which have now come to the fore, and I remember in Tolstoy's novel Anna Karenina, we find a situation where a person having a relationship with a lady outside the marriage was considered as a taboo, and society was disgusted with that kind of relationship. Even you might have also read a very famous novel called Madame Bovary by Gustave Flaubert. That novel, after it was published, went to the court. It was questioned on the ground of immorality, and ultimately the author won the case. Judgment is also now part of that novel. It is at the back in the postscript. There also we find that a person living with a lady outside his marriage was considered as a taboo in society. Today, the situation is slowly giving way. People are living with ex. They also have got a wife, a legally wedded wife. Circumstances make them to live together. Then what should happen in such situations now? Therefore, this concept of living relationship has also given rise to change, a necessity for change in the law. Now, we have what is known as the provision of divorce. In Hindu Marriage Act, we have section on divorce. Divorce can be granted subject to any one of the following grounds being satisfied. Is there any such law with regard to living relationship? Do you have any divorce provision in living relationship? We don't have. If you don't have a provision for divorce, then what does it mean? Are you recognizing that as a marriage? No. Then what are the implications of that kind of relationship? Not only this concept of living relationship has also been recognized in another act of India called as Protection of Women from Domestic Violence Act 2005, shortly called Domestic Violence Act. There, the definition of a person who is aggrieved is like this. It says, it also includes a person who is or has been in a domestic relationship. What do you mean by domestic relationship? That is being defined in section 2F as it also covers, among other things, those who have lived together in a shared household through a relationship in the nature of marriage, not marriage. If a person live together in the nature of marriage, that's called as domestic relationship. Now, a person who fits in definition of agreed person in this act will have got the same remedies like the wife has got under Domestic Violence Act. But beyond that, if you look at it, she has no right of divorce, no law is there. Not only that, it is difficult, it is now said, it is very easy to walk into this live-in relationship, but difficult to walk out because there is no divorce provision. I had many cases in the High Court of this type. Many unfortunate ladies who did not know that the person was already married, they lived with him without getting married. Children were born, and the husband then said, "You go out, I will not care for you." Now, Domestic Violence Act comes to aid of such persons. But still, there are several problems which require to be answered. Now, the Supreme Court, recently in one case known as Revan Siddhappa versus Mallikarjuna, it went to the extent of saying that the property of a Hindu male who dies intestate was given in that case to a woman with whom deceased had a live-in relationship. It was given in that particular case. Now, Supreme Court has said that if the persons live together for a particular for some time, a period of some period of time, you can say that they are living as husband and wife. What is that period? How long they should live together, live in a relationship? There is no exact period mentioned. Years or months, what? Not known there. Then, this is one problem. Then, the next one is, what about the children who are born out of live-in relationship? Whether they will get right in the property or not, how they should be treated. Now, we have the provision of law which says that the children born out of illegitimate marriage are given certain rights. They are given even the property rights also. And the Supreme Court said in one case that in the case of Vidyadhari versus Sukrani Bai, Supreme Court said children born out of a second marriage would be legitimate, though second marriage is void. They said it here. Then, so today they will not be taken considered as illegitimate children here. Now the debates are going on in the country. Social opinion is now being gathered to bring about changes in the law. Now the moot question is this: where do you put in this live-in relationship? Can it be put in the personal laws of the person? It is a very important issue that requires to be examined, and how to put it there. If you fit the live-in relationship into personal law, say Hindus or Muslim, whatever it is, what will be its impact? If you put it there, legally wedded wife and children, they will be having lot of problems. Lot of harm will be caused to them. Secondly, if you allow a live-in relationship to be brought within the fold of personal laws, then are you not giving a stamp of approval for the bigamy? Is not bigamy penalized in the country? So what should happen? So where is the law for that? So these are all serious issues which will touch upon the lives of many persons in the country, and they all require a lot of thinking, and legislation should have to take care of all these aspects. Extending my talk on the family law, let me take you to another important field, genetic engineering. What do you mean by genetic engineering? Now, this is nothing but the field of medical science where a lot of research has led into the biological aspect and birth of a child. And today, couple who cannot beget children, infertility being one of the reasons for that, they can go and have a child. There are so many clinics are there where they can go and get this child. Now, there are so many ways of this happening. Now, from the nucleus from the skin cell of an adult frog was taken out. The nucleus from this skin cell of an adult frog was taken out. It was inserted into unfertilized frog egg. That is, another frog was there. Take out the egg, remove the nucleus, the original nucleus from that, and put this nucleus, that is the skin cell, from skin cell you take out from this frog, put it there. The frog was born. That frog had all the qualities of the transplanting frog. So, what is the effect now? I don't know whether you have read the book of Aldous Huxley, The Brave New World. There he had prophesied or fantasized a society where you will have same types of people, alpha type, beta type, and gamma type. Now, that is becoming today a reality. You can have a child resembling Einstein or Lincoln or any great personality you want. You can have by this method. Stereotype society will be there. People will be of the same type, same qualities. Where are we heading? So, what was fantasized by Aldous Huxley is now being proved to be a fact in existence. Now, not only that, look at another area, this medical science, genetic engineering now. That is what is called surrogate mother. What do you mean surrogacy now? Surrogacy is nothing but a woman carrying the child of another woman and giving birth to that child. After the child is born, is given to the intending parents. Her job is to carry the child. This is called as surrogacy. Now, complex issues have arisen even in this area also. Surrogacy is the process of carrying and delivering a child for another person. Now, India, for your information, India has become the hot favorite of many foreigners for this surrogate child. Because in one of the articles which I recently read, which is also published in one of the Supreme Court journals, a village called Anand in Gujarat is very famous for outsourcing of this surrogacy. There, people, they give birth to children of foreigners. How do they do? $25,000, $30,000 is given to that surrogate mother, and the foreigners take home the child and to their place. So they take the child, she gets the money. Why do they come to India? The reason is the cost is very, very less in India. This $25,000 is one-third of the cost in developed countries. Therefore, many countries have started coming to India, and we can say they are exploiting the Indian women also because they want money and they want the child. Now, this surrogacy has led to an important case also reaching the High Court of Gujarat, and now the matter has come before the Supreme Court. The issue involved is this one. It's very simple here. A person by name Balaz, a person by name Balaz came to India along with his wife. They wanted children. They took the help of a surrogate mother. Agreement was reached between them. Then she gave birth to twins, that lady. These two twins are, what happened in this case was, the surrogate mother, she donated the eggs. Eggs were given by her, and they were fertilized with the sperm of the husband. That is, this gentleman called Balas. Then twins were born, and they were to go back to their native place. This Mr. Balas, he was a freelance writer. He comes from Germany. They want to go back to Germany. Now passport is required. So the passport authorities issued passport. Who is the mother? The column is there, mother. They put mother's name as Mrs. Balas. Was Mrs. Balas the mother? No. She did not conceive the child. Somebody else, some unknown woman in Gujarat, she conceived the child, everything. So what happened? So the passport authority said, we cannot give you a passport because you are violating the Birth and Death Registration Act. Provision are violated. They said you will take it back. This man gave the passport back to the authorities, went to the High Court. High Court said, give him passport. Matt now is in Supreme Court, in the appeal. Now this is a very important issue, because why did the couple ask for a passport here? In Germany, surrogacy is not recognized in law. In several countries, it is opposed to public policy. They don't recognize surrogacy at all. Germany doesn't allow that. Now, the child, if is taken to Germany, they will not recognize surrogacy. All right. What about the position in India? What about the child's right of becoming a citizen? Can the child be an Indian citizen? Can the child be Indian citizen? If you take the Citizenship Act, read the provisions, you will find one of the parents must be of Indian origin, one of the parents must be Indian, something like you read here. Here both the parents are from Germany, so the child will not get Indian citizenship, child will not be taken to Germany. What will happen? Now the government of India has come up with a possible solution. There is an agency called a Central Adoption Reserve Agency, some CARA agency there. The government has said, we request that agency to relax the rules of adoption and make it as if it is a case of adoption. The government has come with a proposal. Now what will happen? If the adoption concept is accepted, then she will become a mother. Surrogate mother will be a mother. Once adoption is accepted, will she not be a mother? She will be called illegal mother. So we have a natural mother, we have a legal mother. Now look at the things happening in the genetic field. In family law is concerned, far-reaching problems are there. Of course, the matter is in Supreme Court. We have to await the judgment of Supreme Court. What the law is going to be, we only have to wait and see. But these are all the problems that the law has to tackle, and you will have to find out some solution. In Britain, there is a law called Human Fertilization and Embryology Act 1990, under which a surrogate mother is taken as a legal mother, and if she gives consent for the child being treated as the child of the commissioning parents, then court will pass an order that effect. She will not give consent for that. If she consents, says, I am not making any claim, let the child be the child of the parents, commissioning parents, it's okay. Now, there are many other issues are there. What about the child itself? What about the child's right? What about the right of this surrogate mother? We have to wait for the decision of the courts, and maybe a law also will have to come in place and find solution to this problem. So this is in the area of family law. Now, likewise, if we go to other aspects, my time is running short. The law also has changed in the field of contract. Individual contract is now replaced by collective bargaining. I join a factory today, I get an order of appointment. Thereafterwards, I can't ask anything. I must go to the union, collective bargaining, they will decide. All things will be decided by collective bargaining method. They will decide everything about my fate. Originally, contract was between two individuals. Today, collective bargaining has stepped in the place. So, there's a change in the law of contract. What about negligence? Negligence is concerned. Now, this has given tortious liability, which is a very age-old concept, is now giving place to insurance law. With development of motor transport everywhere, today we find insurance law is there. You cannot take your vehicle out without having a policy. There must be a policy of insurance. Some accident occurs, insurance company will pay the compensation and not the owner of the vehicle, provided you don't violate any of the terms and conditions of the policy. Insurance law has come into place. What about Consumer Protection Act? That is also there now. Any defect in the goods, you can go to consumer court and file a petition. So these are all the other areas where law is also changing thick and fast. And one other mode of change in the law is judicial lawmaking. Of course, Supreme Court and Article 141, it lays down the law, that will be the law of the land, applicable to all the courts and tribunals. Now, so many cases have come up before the courts, and Supreme Court, through the mode of interpreting the Constitution, interpreting the provisions of law, has laid so many principles, which are all nothing but judge-made law. Can the judge make law? Is it open to him to make law? Yes, says Lord Denning. This is what Lord Denning says. The proper role of a judge is to do justice between the parties before him. If there is any rule of law which impairs the doing of justice, then it is the province of the judge to do all that is legitimately he can do to avoid injustice. He will have to step in and do that. This is what is called judicial lawmaking. And this judicial lawmaking in the country has led to so many changes being brought about in the law. We have the famous case of Gokhale case was there regarding amendment rights. Then came Kesan Bhati case. Then we have ADM Jabalpur versus Shivkant Shukla's case. Article 21 was subject matter there. Vishaka versus State of Rajasthan, a case of giving protection to working women about sexual harassment. Union Carbide case regarding the polluter case, and many other case laws have developed through judicial lawmaking process. So these are all the ways by which the law keeps on changing, so that it is in tune with the changes taking place in the society. Now, to conclude my talk, changing society has modified the content of law. Law cannot remain static. It has to move and in tune with the changes taking place in society. Now, if the law keeps on changing, and the contents of law keeps on changing, will it not be possible for us to have a pessimistic view of law, saying, the law keeps on changing like this, how do I know what is the content of law? The contents of law keeps on changing time and again because of various factors. How do I know what the law is? So that is the kind of pessimistic view expressed by some person. For that, the answer given by Professor Friedman is this. He says, it would be tragic if the law were so petrified so as to be unable to respond to the unending challenge taking place through evolutionary methods in society. Today, a lawyer cannot remain by saying that I know the craft of my profession, enough for me. No, you will have to become a jurist apart from becoming a lawyer. Friedman says, Today, the lawyer cannot remain as a craftsman. His sense of responsibility for the society in which he lives must inspire him to be a jurist as well as a lawyer. Therefore, distinguished audience, ladies and gentlemen, I have, in the limited time given to me, I have tried to put before you various development in society, how it has affected the content of law, how law should respond to these challenges. Let me thank you for your very patient hearing, and I am grateful to the Gokhale Institute of Public Affairs for giving me this opportunity to share a few of my thoughts on this topic, and I hope that this talk will certainly create an awareness among you, an awareness as to what should be the content of law, why law should change, what's happening in society. Keep our eyes and minds open and see development taking place all around us. And I am also thankful to my classmate and advocate, Mr. Chandrasekhar, who is present here, who is principally responsible in bringing me to this institute on the last occasion. And I am thankful to all the officers of this prestigious institution, and also to Justice Purswami, President of the Liberal Forum. And with these words, I take leave. Thank you very much.
I thank Justice Jagannathan for a thought-provoking lecture on the changes required in the laws. Sir, I just want to know, one of the purpose for the changes in the law is for the speedy implementation of justice. Particularly, I just want to one or two instances I want to quote, sir. This Negotiable Instruments Act, I think it was amended so that Section 138 was to be brought in so that for a speedy trial in the court. But generally, we see same procedure is taking place. Even a private complaint, see the Act very specifically says under the Negotiable Instruments Act, if the banks gives a authority or banks gives a confirmation that there is a denial of check, there is a conclusive proof. But despite that, the same routine things will be taken care, will be followed, and it takes years. And in this case also, I personally feel that as the Kannada proverb says, "Geddon sota soton satta." The same thing is happening. Therefore, the speedy implementation, I think, is just a eyewash, I personally feel, in particularly in case of Negotiable Instruments Act. Secondly, sir, about this public servant definition is not very clear to me. Of course, what I am telling is, it is only a coincidental, but it is not accidental. It is not intentional, because I was just thinking, say, if a person where huge money, lakhs of rupees are spent on his Z category security, and the cabinet ministers come to his defense for his action or inaction, still that man is considered to be as a private citizen. Therefore, this Corruption Act or the corruption charges cannot be pursued against him. Therefore, don't you think, sir, this corruption, to make a very effective this thing for anti-corruption thing, the definition of public servant should be changed? These are the two small questions I just want to ask. Thank you.
Now, let me respond to this by saying at the outset, the topic that was discussed today is about the law in a changing society. We are basically concerned with the need for change in the law, the need for modification in the law on account of change taking place in society. Therefore, let me say that the questions that were posed were really not related to the topic which we have been discussing here. But nevertheless, as he has put this question, let me also give answer to it. Now, as far as the Negotiable Instrument Act is concerned, as I said, we have a provision of law, Section 138 of NI Act tells about the offence there. Now, unless the necessary elements of the section are fulfilled, it will not be an offence at all. That is one thing. As far as the delay is concerned, there are already many steps have been taken. the cases which are under NI Act, though large in number, have now been settled in local adalat, and efforts will be made to see that they are disposed of in within a reasonable time. But as you know very well, that in India we have less number of judges when compared to the population ratio. That's one of the factors. And secondly, even the procedures also will have to undergo a series of change, so that people do not have to wait for long years to get back their money which they had lent out somebody by way of checks. So this is one thing. As far as the public servant is concerned, here again, public servant is defined in various enactments in various means. You take, for example, the CRPC, we have some definition there. You take the latest act, or the act which is now being discussed everywhere, Prevention of Corruption Act, there you got definition of what is a public servant. So that definition will be looked into to find out whether a particular person is a public servant or not. To give an immediate answer to this concept, that I can only tell you, in the words of Supreme Court, a person, though may not be a public servant as such, if he is discharging public duties, he will be called as a public servant. This is the expanded definition given by the courts as to who is a public servant. So the scope has now been widened. Even private companies, private firms, if they are engaged in public service, they will be called as public servant. So Supreme Court has expanded the concept of public servant. These are the two questions you have put. And
I have got a question on the changing laws.
yes, come, please come.
Your talk was highly informative, and definitely you have seen all the changing laws, especially the cyber crime. See, why I am talking of cyber crime is today we are in the world of internet banking, mobile banking and all. This cyber crime, what I have seen, the hacking of the websites, especially I have seen defense websites has been hacked, and I have not found what is the punishment given to any this one. This I want to know. And next thing is, what about international courts? You told, for example, India is making some brand and China is making some brand. Where you will go? When justice is not done by Supreme Court level, then can you go to international court? These are the two questions I wanted to pose to you.
Okay. Now, as far as the cyber crime is concerned, we have got an act called IT Act, Information Technology Act. That act defines various offences under the cyber law and also gives punishment for them. But as you rightly put it, there is some difficulty, in establishing the cyber crime because of the following reasons. One is, as I mentioned about the cyber space here, where do you go? To which court you will go to detect this particular crime? And secondly, how do you preserve the evidence? There's an article about digital signature, digital records. Where do you keep them? How do you preserve them? So these are all the problems that are there, which will have to be addressed by the legislation. And though the IT Act, Information Technology Act, says that this digital record, digital signature can also be approved under the Indian Evidence Act, Section 65 or whatever it is. There are many grey areas which have been responsible for not being able to establish a guilt of a person in cyber field is concerned. Very difficult to preserve the evidence, very difficult to prove where it happened, and very difficult to locate the jurisdiction is one thing. The second aspect is concerned international court, you mentioned. Now, the example that I gave about surrogate mother is concerned, about the case of a child being taken to Germany, not being recognized there. In some countries, they have passed certain legislations saying if the surrogate mother or if the surrogate child is born by following this following procedure, we will give them recognition. We will recognize the child. That is the position in Australia. In some countries, they say it is opposed to public policy, we will not recognize them. Likewise, the matters which go to this international field, certainly they will have to be tackled by the international court. Let me also tell you about what's happening in the case related to fishermen being caught in Kerala shore and Italian person being brought there. Now the matter is in the Supreme Court. So these are all very complex issues which only ultimately Supreme Court will have to give necessary guidelines as to which court they should go. And maybe in course of time, because of the world now getting shrunken, because of the internet and computer, the whole world now became a very, very small ball. Sitting in Bangalore, I can correspond with my client who is in Dubai and Australia, do the work in my house and get my fees paid. If something often takes place, where do you go there? So probably a time will come when the international community also will take note of all these things. I will try to find out a common solution.
Thank you, sir.
Okay.
We need cyber laws and all. Thank you very much.
My main question is, I think we are already having a lot of problems for the common man, and a lot of laws are confusing, etc., and already we are in deep trouble. In the meanwhile, you have come out with so many issues in new technologies, etc. I want to know who should make the law when somebody is producing something new. I think it is the responsibility of the community who is producing that. Suppose if it is genetic engineers, it is genetic engineers, they should come out with something and then they should introduce the product. The same thing in the cyber law, in the internet technology, etc. But that is not happening. It should not be passed on to judiciary or parliament. It is the responsibility of the responsible expertise, and it should not lie with parliament or this one. They should only take suggestions from them, and I think it should be discussed thoroughly, and before something is made really practical and it is implemented in the society. But most of the problems, as we have seen, because somebody has not given a thought in advance. That's what we do even when we do a small project in the college. Why it is happening? Why such a simple thing is not taken care of? When we are having so many basic problems we are facing, as I felt very bad that I think law is not going in a proper course.
Okay. Now, I am happy that this talk has given rise to so many questions being posed. That itself shows the importance of the topic and necessity of awareness. Now, so far as the question that is put is concerned, judiciary will interpret the law. Laws are interpreted by the courts, by judicial lawmaking, judicial review is there. Whenever an act is questioned on the ground of constitutionality, the Supreme Court will give the answer, and in the process, it also lays down the law, as I mentioned in the judicial lawmaking process. When the law is there, Supreme Court will and High Courts will interpret the law, and wherever there are grey areas, probably they will also lay down new principle or new guideline. This one thing. Wherever. If no law is there, then who should make the law? Judiciary will step in. If no law is there, covering a particular field of human affairs, covering a particular aspect, judiciary will step in and it will lay down the law. But if law is already there, the task of the judiciary is to interpret the law and clarify the grey areas and maybe to lay down principles. But making of the law as such is the prerogative of the legislature. Law making is the function of the legislature. Its implementation is by the executive. It's how to interpret the law is in the hands of the courts. Therefore, if we are having new problems, as I mentioned in my talk, social opinion, public pressure, expressed through electronic media, press, conferences, associations, all this, and elected representatives, all these agencies, they can bring to bear on the parliament the need for a new law. Make a new law in this area. We don't have a new law. They will have to pass new legislation. Once again, that will be subjected to scrutiny by the courts. It is said in a popular sense, for every problem, solution is to pass a law. More problems and more laws. More laws, more problems. This goes on. Law has to keep on changing. Ultimately, law making is the prerogative of the legislature. They alone can make the laws. But judiciary can only play the role of making law in these limited areas of judicial review, constitutional validity, or where no law is there, judiciary will step in and it will give the answers. Therefore, this is a question of law making by legislature. They will have to be very wise. They will have to feel the pulse of the people and what they require, what the law they want. How are we to address these problems? That's why I said this kind of discussion, debates, etc., they will all help ultimately. And articles by students in various journals and magazines, all this will add up to a kind of model being created and put in place by the parliament. And the government of the day has got overwhelming majority, laws will be very easily passed. But the government is not having majority, you know what's happening, the problems will be there. These are all the things. Okay.
Jagannathan has delivered a most interesting and crucially important subject. Maybe it's just an aside. It seems to be a small world. I was happy to know that he was with the firm of King and Partridge. It happened that in an earlier era, I had a peripheral relationship with King and Partridge. Oh. The person who earlier headed King and Partridge, it was before your time, perhaps Mr. Putsami would know Mr. Muirhead. Aye. Mr. Muirhead, who earlier headed King and Partridge, he wrote an Indian supplement to a legal classic called Cross on Evidence. There is an international standard book on evidence called Cross on Evidence, and an Indian supplement was needed. Mr. Muirhead wrote that book, an Indian supplement to Cross on Evidence. So I had some role in helping him and printing it and publishing it and so on. And subsequently, I also happened to be associated with Mr. T. Subbarao, who later headed King and Partridge. So it's a small world. I was glad you mentioned Henry Main's book on ancient law. It happened that in this institute study circle, we studied Main's book as a textbook under the guidance of D.V. Gundappa. Justice Jagannathan has mentioned how, by its very nature, law cannot remain static. He quoted the Dalmia case pronouncement and so on, namely that law is a manifestation of justice, equity, and norms of good conduct and so on. And as he said repeatedly, law does not operate in a vacuum. And then he mentioned the mechanism for change of law. And then apart from mentioning what changes have taken place in recent times, he also mentioned some emerging areas of interest like divorce law, concept of property, cyber world, environmental issues have gained prominence. I have myself had occasion to lead some litigation in the Supreme Court about environmental issues. And then the same gender marriages, then how abortion has become a major issue in many countries. Should suicide be legalized? And then how cyber crimes are increasing, and as of now, courts are clueless. I suppose it's a matter of time. In fact, cyber crimes have increased so much that most often even the aggrieved people do not approach courts for the reason that it might gain publicity and lead to more cyber crimes. Now he mentioned the complications arising from live-in relationships genetic engineering and surrogacy, collective bargaining, and Consumer Protection Act, and so on. So it's a, as he said, law is a product of constant interaction between various segments of society, and there are obviously no quick solutions to complex issues. Law has to evolve over a time. That is how it has always happened. That is how it will happen in future also. Law can only evolve over a period of time. On behalf of Indian Liberal Group Bangalore Chapter and Gokhale Institute of Public Affairs, I am expressing our gratitude to Justice V. Jagannathan for a most enlightening and topical presentation. Thank you, sir. I request Justice Putswamy to come onto the stage and honor the lecturer.